Hello everyone. The question we are going to discuss today is compare and contrast the respective approaches of the English and Malaysian law of contract towards duress as a vitiating factor. What is duress? In jurisprudence, it stated that duress related to a situation whereby a person performs an act as a result of violence, threat, or other pressure against a person. In Black's Law Dictionary, it defines duress as an unlawful threat or coercion used to induce someone to act or not to act in a manner they otherwise would not do or would do something. Under Malaysian law in Contract Act 1950, Section 15, it states that coercion is the committing or threatening to commit any act forbidden by the penal code, or the unlawful detaining or threatening to detain any property to the prejudice of any person, whatever with the intention of causing any person to enter into the agreement. As from Treacle, he stated that the consent of a contracting party may have been obtained by some form of pressure which the law regards as improper. The victim of such pressure may be entitled to relief under the common law rules of duress and under the equitable rules of undue influence. From the quotation, we know that a party or person can set a contract aside if that party or person has been forced or coerced into the contract. If the coercion can be shown to be true or be proved, the contract and the entire contract can be considered as an invalid agreement. Traditionally, duress related to the duress to person, which required actual violence or threatened violence. Nowadays, the application of duress has since expanded. Duress may be economic in nature, deal with threat of damage to property or goods, threat or demands for money. When duress exists in a contract, any money paid over where there was no obligation to pay it and a person was under threat of damage to goods may be recovered. The courts will state that in such circumstances, the person will make it clear that the payment was being made under protest. When a person entered the contract because of threats of physical violence, the contract may set aside providing the threats was the cause of entering into the contract. The case Barton and Armstrong related to the person of duress. In this case, Armstrong, who is the previous chairman of the company, threatened Barton, who is the managing director, with death if he did not agree to purchase Armstrong's shares in the company. There was some evidence that Barton thought the proposed agreement was a satisfactory business agreement, both from his own point of view and that of the company. Barton executed a deed on behalf of the company carrying out the agreement. He sought a declaration that the deed was executed under the duress and was void. In trial, the judge held that Barton could not plead duress since he had not established that he would not have entered the agreement without the threat being made. However, on appeal, the Privy Council held that if Armstrong's threat were a reason for Barton's executing the deed, he was entitled to relief even though he might well have entered into the contract if Armstrong had uttered no threat to induce him to do so. The onus was Armstrong to prove that his threat was not a reason to make Barton to make into the decision. The later case was taken over the view that duress and equity will make a contract voidable rather than void. In the case Griffin and Griffin, a young man was threatened with imprisonment if he did not marry with a young girl who he was alleged to have made pregnant while on holiday and Holyhead. If he got imprisonment, he and his father will lose their job. He then caved into the pressure and married the girl. Later, it transpired that he was not in fact the father of the child. He then successfully claimed that the contract of marriage is void because of duress. The case Rock and Millie indicated that a person threatened with the prosecution of near relative unless he or she undertook to pay the debt owed by the relation may in certain circumstances be able to plead duress in equity.
The second type of duress is duress of goods. Traditionally, as decided in the case of Skitty and Millie, threatening on goods to make payment is not an operative duress. But as Lee and Reynolds says that recover money already paid under duress of goods is operative duress. In the case of Skitty and Millie, defendant is the tenant whose goods was wrongfully detained by his landlord because of owing rental to the landlord. The defendant promised to make part of the payment immediately and the balance of the rental within a month's time. Subsequently, defendant failed to do so and plaintiff sued on the agreement. And the defendant argued that the agreement was voidable due to duress and the plaintiff's act of detaining and threatening to sell his goods is wrongful. The court held that plaintiff's act of detaining and threatening to sell his goods is insufficient to render the contract voidable, therefore he cannot recover his money. However, in the case of Ashley and Reynolds, it was held that the payment made under duress of goods is recoverable. In this case, the plaintiff kept his goods to the pawnbroker who is the defendant, and when the plaintiff wishes to redeem his goods, defendant wrongfully rejected him unless the plaintiff paid the interest chargeable legally. The plaintiff did pay the money and later sought for recovery under duress of goods. Similarly, in the case of Muscle and Hornung, the defendant threatened plaintiff to close down plaintiff's market store and seize his goods if plaintiff did not pay the toll money. But in fact, the defendant has no right in law to take those toll. It was held that plaintiff can recover his money, and if anyone paid money that he was not bound to pay, but paid under duress, the money is recoverable. In a modern position, the Sebon and Sebon made an obited dicta that duress of goods is an operative duress. And in the case of Avia Luck, agreed to the obiter and state that Skitty and Billy is no longer a good law.
Now I will talk about the economic duress. Economic duress was a late arrival in English law. It was not formally recognized until the case of the Siboyan and the Sibo trade. So, what is economic duress? It means one party uses his superior economic power in an illegitimate manner in order to induce the other party to agree to enter into a contract or to agree on particular terms of the contract or to break an existing contract between the parties. There are two central elements in the doctrine of economic duress. First, legitimate pressure was applied by one party, and secondly, the pressure constitutes a cause inducing the other party to enter into the contract. A threatened breach of contract can constitute a legitimate pressure, but a refusal to contract unless certain conditions are met or a refusal to waive existing contractual obligations do not constitute the application of illegitimate pressure. We shall now examine the leading case in economic duress, the Atlantic Baron. In this case, the defendants agreed to build a ship for the claimants in US dollars. However, the US dollars was devalued by 10% afterwards. The defendant threatened not to complete the contract unless the claimants paid an additional 10% on the contractually agreed price. Hence, the claimants paid the additional sums without protest. The claimants sought to recover the additional sum 8 months later. In these circumstances, the courts held that the contract was voidable for duress. However, since the claimants were delayed in bringing the action and were not protesting when making the payment, by which the trades were no longer real, the claimant had lost their rights to rescind. In the case of Pao On and Lau Il Long, Lord's government stated that duress is a coercion of the will so as to vitiate the consent. That is to say, the agreement must have been involuntary. However, in the case of the Universe Sentinel, the focus of judicial attention moved from the thought process of the victim towards the nature of pressure applied by the other party. In this case, the defendant black achieved the Universe Sentinel to prevent it from leaving the pot. They made several demands, including paying a large sum of money to a welfare fund. In order to leave the pot, the appellant agreed and paid for the sum. The appellant then sought to recover the sum that they paid to the welfare fund. In these circumstances, House of Lords held that the money had been extracted under economic duress, and it could be recovered. The earlier case law had been wrong to look at coercion of the will so as to vitiate consent. During an analogy with the defense in criminal law, where it is recognized that a defendant acting under duress has the intention to commit the offense, but is excused from the crime because they had no choice but to submit. After that, Cartwright had summarized when can the pressure be illegitimate. First, the thing threatened is unlawful, and secondly, the way in which the pressure is exerted is illegitimate. Thus, the vital question becomes whether or not the pressure applied by the party was illegitimate. But it remained important to consider the position of the victim, but only for the purpose of establishing whether or not there was a sufficient causal link between the pressure applied by the defendant and the decision of the claimant to enter into the contract. A third element was established in the case of B&S Contracts and Design Limited and Victor Green Publications Limited. Judges started to base their decision upon the lack of reasonable alternative open to defendant. In this case, a week before the exhibition, the appellant told the defendant that the contract would be cancelled. The defendant had to pay the additional sum to meet the claims to avoid the contract to be cancelled. The consequence of not paying the claims might have exposed him to a heavier claim for damages from the exhibitions. It was held that the payment had been made under duress and appeal was unsuccessful as they had not demonstrated that they had taken every effort to carry out the contract. Under Malaysian law, Contract Act does not provide any form of coercion other than as defined by Section 15. This was established in the case of Police Plantation Berhad and Muhammad Abdullah Am. However, some later authorities appear to recognize the doctrine of economic duress in principle, although it was not established on the facts. In the case of Muhammad Farid Subramaniam and Nazam Motor Trading Sendirian Berhad, the plaintiff had rented a taxi from the defendant at an agreed daily rental. Subsequently, the plaintiff signed a variation agreement giving the defendant the right to repossess his taxi if he failed to pay the daily rental. The plaintiffs then sought to invalidate the variation agreement on grounds of economic duress. The High Court found that there was no coercion in this case. The plaintiff made no protest either before or after the agreement was executed. That is to say, he admitted that the contents in the agreement were read to him and no force was applied to make him sign the agreement. There was no evidence that he had taken any steps subsequently to repudiate the agreement.
Now, we move on to the comparison between English and Malaysian law of duress. In common law, economic duress was first recognized in the case of Sibon and Sibotret, where it involves the variation of the existing contract. While in Malaysian law, although economic duress has never been expressly recognized by Malaysian court, but some cases seem to recognize that the principle of economic duress do apply in Malaysian cases. For example, in the case of Taekwon trading and hydrotech engineering. At first, the test used was the overborne wheel theory. The overborne wheel theory was first clearly introduced in the case of Sibon and Sibotret, where the court focuses on the free consent of the contracting parties. Then it switches in the case of Universe Sentinel, where the court now focuses on the illegitimacy of the pressure. In contrast, Malaysian court still recognizes the free will theory as the test for duress. That case that justifies this rule is the Indian case of Kanhaya National and National Bank of India Limited, which is followed by the Malaysian courts as our Contracts Act developed from the Indian Contracts Act. And although Malaysian courts have recently seems to recognize economic duress under common law, but the test still focuses on the coercion of will. In Section 15 of Contracts Act 1950, to the prejudice of any person may suggest to include substantive unfairness and also the unfairness of the process. But under common law, the courts only look at the unfairness of the contracting process. And again, under Section 15 of the Contracts Act, it does not state that party committing coercive act must be the party to the contract. Therefore, coercion may come from third party, and third party may also suffer coercion. But third party is not included in common law. Common law does not require the intention to cause entry, although it is an implied requirement. But under Malaysian law, there must be an intention to induce the other party to enter into an agreement. Lastly, to establish duress in common law, the party must prove that the threat is unlawful. And to determine if the act is unlawful, it is based on the fact of the case. And under Malaysian law, the unlawful act as stated in Section 15 of Contracts Act is the acts in the penal code.
The English common law recognized traits of unlawful physical violence. Recently, economic duress is being recognized, giving rise to a valid claim. Contract is voidable but not void. In the case of IFR Limited and Federal Trade Spa, there was an agreement between an English and an Italian company. According to the Italian law, the termination would give rise to compensation. However, in English law, no such compensation was payable. Federal sought to raise duress to render the 1998 agreement void so as to take advantage of the Italian right to compensation. The effect of a finding of duress has always been to render the contract voidable as opposed to void. However, a voidable contract would not have aided Federal as they had acted on the contract without protest for nearly 2 years, so would most certainly to have lost their right to rescind. Under the Malaysian law, coercion covers under the Penal Code. According to Section 19, the Contracts Act 1950, contract is voidable at the option of the party whose consent was not free. Section 2, subsection 1 states that only party whose consent was not free has the right to have the contract voidable.
A remedy is a form of court enforcement of a legal right resulting from a successful civil lawsuit. Under the English law, the effect of duress is to make the contract voidable. The injured party will, therefore, be entitled to have the contract set aside for operative duress, unless he has expressly or impliedly affirmed it. The victim of duress must seek rescission as soon as possible after the original pressure has ceased to operate. And this can be seen in the case of Atlantic Baron, which has already been discussed under the economic duress. The effect of rescission under the Penal Code can be seen under the Section 65 of the Contracts Act 1950, where one party rescinds a contract, the other party is excused from further performance, and the rescinding party must restore any benefit received under voidable contract. According to Section 66, when an agreement is discovered to be void or a contract becomes void, any party who receives any advantage under the contract must restore any advantage received or make compensation. Section 76 states that the rescinding party is entitled to compensation for any damage sustained through non-fulfillment contract. It does not apply to voidable contract, but applied in situations where a contract has been rescinded for breach. General scope and limitation to defense of duress in English law was given by the House of Lords in R. and Hassan. In this case, the defendant was convicted of burglary and used duress as a defense in trial. The conviction was quashed as he was plead harm, but later, the House of Lords restored the defendant's conviction by saying that the defendant was not allowed to exclude his conviction just because he was threatened. It is a duress of circumstances and in need of more limitations. The Penal Code covers a wide range of offences. The law is wider than English common law, and duress to goods is expressly recognized. Section 15 of the Contracts Act 1950 does not state that a person committing the coercive act must be a party to the agreement. Ideally, duress of goods should be narrowed down, and moreover, Section 15 has to be reviewed to overcome uncertainty. In conclusion, duress in English law is a complete common law defense. It operates in favor of those who committed an act because being forced or compelled to do so. In Malaysia, it is a defense against committing an act forbidden by the Penal Code. Application needs to have its limits, and some developments need to be done before being relied on.